Okay, guys, Management 209, 211. This is exam 2, part 1 material. This is personal intentional torts. You should have the red packet for this review, and we are going to do the first few questions in the front of the packet. Now we're going to do about 5 of them. We're going to leave the last 5 for a little bit later, but then we're going to get started. And you'll need your study guide with you at all times. Okay, let's go ahead and get question number 1. Ted, who is blind, is accosted and his wallet taken by Marshall, age 25. Ted uses a knife to attack his unarmed Marshall while the wallet is being stolen, and as a result, Marshall is killed. If Ted were to be sued by Marshall's family for legal damages, what would the likely result of the trial based upon tort law be? Ted would likely lose and have to pay damages to Marshall's family for assault, even if he was the one attacked first. Ted would lose for battery, even if in Texas, as he had no duty to flee the situation under Castle law. The jury, based upon reasonable doubt, would likely find that Ted was justified in his actions and thus find him not responsible under tort law. Ted would likely avoid liability by a jury's decision. Ted would likely have to pay damages if, after Marshall's death, he defamed his character by telling everyone Marshall was a thief after his death and the action occurred in Texas. Okay, so we go through each of these answers. Number 1, or letter A, is Ted would likely lose and have to pay damages to Marshall's family for assault. Assault really doesn't apply here. It's going to be battery. Ted would lose for battery, even if in Texas, if he had he had no duty to flee the situation under the Castle law. That really doesn't apply as much because we're not talking necessarily about Castle law, and there is no duty to flee in Texas. The jury, based upon reasonable doubt, we don't care about reasonable doubt, we're talking about tort law, which is a civil wrong, not a criminal action. So we're going to use preponderance of the evidence rather than reasonable doubt. Ted would likely avoid liability by the jury's decision. That sounds good. Ted would likely have to pay for damages if, after Marshall's death, he defamed his character by telling everyone Marshall was a thief after his death. Well, that's a defamation of character question portion. And even though it doesn't apply to this question, the answer still would be incorrect because Marshall did try to commit a theft, therefore it is a true statement. So the best answer is D. Why is the best answer D? Because the jury's decision is likely based upon what would a reasonable person, average person deem in this situation. And Texas kind of likes a lot of gunplay anyway, so note that. We'll find that in the study guide a little later. Number 2, Ted, a local student at TANU says false statements about regarding a presidential candidate during a speech in his political science class. If Bernie Sanders were to sue that local student under tort law, which of the following would be necessary for Bernie to win? If the statements made by the student were true, yet injured his reputation to the point that he lost the political party's nomination, he could sue the student and win for legal damages under defamation of character. Could sue and win under invasion of privacy if statements he made by the student were in fact true, but details of Bernie Sanders' private life by telling everyone that he is gay. If the statements made by the student were false, and in fact he isn't gay, then Bernie could win a defamation case if he could show the libelous statements made were intended with malice. D, if the statements made by the student were true, and in fact he is gay, then Bernie could win a defamation case if he could show that he made these slanderous statements with intended malice. The student would likely win a defamation case if he can prolong the trial because Bernie Sanders looks close to death, and his death would give the student protection under the law in regards to false statements under defamation laws. Well, that answer doesn't apply because he would have done it while Bernie Sanders was still alive. Answer A, if these statements were true, even if it injures a good name or reputation, there's no false statement, therefore no defamation. He could sue and win under invasion of privacy, this being Bernie Sanders, if the statements made by the student were in fact true, but details of Bernie Sanders' private life by telling everyone that he is gay. If he is gay, therefore the answers are true, but it's affecting his or a portion of his private life. Bernie Sanders, even a political figure, a celebrity, has protection from his private life, certain details of his private life. So B is a good answer. If the statements made by the student were false, and in fact he isn't gay, then Bernie could win a defamation case if he could show the libelous statements when intended malice. Well, this wouldn't be libel, this would be more slanderous statements. So C isn't correct there. If the statements made by the student were true, and in fact he is gay, then Bernie could win a defamation case if he made slanderous statements with intended malice. Well, if the statements are true, once again, not false, so therefore no defamation. The student would likely win a defamation case if prolonging the trial. We already talked about that one being appropriate because he was already alive and it wouldn't apply there. The best answer here for number 2 is B. Which tort law was not recognized in Texas until the 1990s and can only be used, which rare itself, when other tort law remedies do not suffice? Abuse of process, malicious prosecution, intentional inflicting of mental distress, intentional interference with prospective economic advantage. Both A and B are correct. Okay? The answer is going to be intentional infliction of mental distress. This is one that Texas rarely allows to be used and didn't even allow it to be until the 1990s. I think 1993, in fact, is the year, which is one of those things that SWIM actually asked on the test. We do not do D in Texas as well, intentional interference with prospective economic advantage, so it's not recognized at all in Texas regardless of year. The best answer for number 3 is C. In a home robbery attempt by armed adults, Ted, the owner of the premises in Texas, A, can use reasonable amount of force to protect property, but never deadly force of just property, must attempt to flee before using deadly force to protect himself and his family, should try to flee the situation by getting his family out a second-story window, all of the above, A and B only, but not C. The answer here, can use deadly force, in fact, also, and reasonable force to protect yourself, others, and in some areas, property in Texas as well. Must attempt to flee. We do not have a duty of flee standard in Texas anymore, so there's no attempt to flee that must be done. Should try to flee. This is your best answer. And the reason is the question didn't ask what is available or not available. It's what is in the best situation. In Texas, he should attempt to flee first. He doesn't have a duty to do so, but he should attempt to flee, and that is your best answer. That's the difference between looking at it from a standpoint of what should you do versus what can you do. And the question asked, and the answer choice C said what you should do, probably your best answer. Number 5. Which of the following defenses to defamation of character would be asked or used if a high-ranking U.S. senator were to have made false statements about a person within his job description? Would this be absolute privilege, constitutional privilege, qualified privilege, or none of the above? And I think I said B, constitutional twice. B was conditional privilege. C was constitutional privilege. The answer is going to be constitutional privilege. This is the Senator Proxmire's Golden Fleece Award case, also known as Hutchinson versus Proxmire, which gives legislators and other public officials the ability to do things constitutionally, giving certain privileges, even if they do make false statements. It is very narrowly construed, meaning there's only certain exceptions within the job framework himself. Okay, we'll do number 6 through 10 if we have time at the very end of the red packet overall. But let's go over the study guide. On page 111 of your study guide, we are going to do the material as we go through the study guide. I will try to reference using the packet itself once again where we are in the packet. These first 4 or 5 40-minute videos will be based upon the red packet. Okay. On page 111 of your study guide, if you have your study guide out, we have not too much on that first page other than a couple of things that we need to go over. One is what is the definition of a tort? If you look on the middle of page 111 of your study guide, it is a civil wrong other than breach of contract for which the law provides a remedy in the form of damages. Now, these damages could be equitable, they could be legal, some form of damages. Equitable being non-money, legal being money. But first off, it is a civil wrong. Therefore, we're going to use the civil stuff like preponderance of the evidence, i.e. more likely than not. You do not get a court-appointed attorney. The Fifth Amendment self-incrimination doctrine doesn't apply to you. None of those things work. Other than breach of contract, which was exam 1, chapter 4, you might have a little questions later on about breach of contract. One dealing with interference with contractual relations later on today. So we're going to have to go over that a little bit in terms of a little trick question that he might have on the exam. Okay. It's similar to criminal law. In fact, an event can be both criminal and civil When we talk about tort law, we're talking about the civil aspect of it, not necessarily the criminal aspect of it. Okay? We're going to punish people typically in civil law and their pocketbooks, meaning money, monetary damages. There are injunctions, there are equitable remedies as well, but for the most part, we're going to go with legal damages, money. All right? Whereas if it's a criminal action, it's going to be by fine or imprisonment for the most part. Okay. If you turn to the next page, on page 112 of your study guide, it has the different types of torts. You have intentional torts, you have negligence, and you have a strict liability. The first thing about intentional torts, it involves a deliberate action resulting in harm. The tortfeasor is the person committing the tort. And the tortfeasor, in order for it to be intentional, must have meant to do the action. And that action resulted in harm to the other. Meaning they meant to do the act. Whatever the act is, they meant to do it. If I shoot a gun, I meant to shoot the gun. If I pull a knife on somebody, I meant to pull a knife. If I pull a chair out from someone and they fall, I meant to pull the chair out. If I swing and try to hit someone, I meant to swing my fist. Those are all things in which the tortfeasor, the person committing the tort, meant to do the act. And if that act resulted in harm to another in some form of damages, then that could be a tort law. Okay? It does not mean that the tortfeasor meant to harm the person. It means that they act resulted in harm to another. And we'll explain that when we get to assault and battery for the most part as well. But one thing that you need to know for test questions is who is the tortfeasor? Because if he says tortfeasor on the exam, you need to know that's basically the person committing the tort. And if they're being sued, likely that is the person that is going to be the defendant. The plaintiff is the one sued. So if he gives you a question and says, who is the tortfeasor in this situation, is the person committing the action. Therefore, likely the defendant, if it is a defamation case, or if it's a invasion of privacy, assault, battery, whatever it is, it's likely the person who is going to be defending themselves in a civil litigation. All right, negligence we will get to in another part. Strict liability we'll definitely get into another part as well later on. But now we need to get to purposes of tort law on page 112 of your study guide. In terms of purposes to tort law, there are 4 different parts: appeasement, justice, deterrence, and social insurance. Now, there's very few questions on this, but we need to go over them real quick. First of all, the appeasement. The appeasement is accomplished in 2 ways: to compensate the victim, and the satisfaction of the defendant for whatever they did is going to have to pay. It is basically a legal way. Appeasement is going to be the legal way to try to, best thing to do is try to make the person whole again. And that's going to go with compensatory damages a little bit later on. We're trying to compensate the victim and making them whole again. Okay? So if, for instance, I was to commit a tort and you were to sue me and your medical expenses were $50,000, then the appeasement is to make you right again, i.e. pay for your medical expenses, your pain and suffering. That is going to be the appeasement. He may have given you a scenario in class about the old lady and the coffee from, say, McDonald's and the old lady in hot coffee. If the hot coffee caused an injury to occur, and say the medical expenses, the pain and suffering equated to $25,000, that would basically be the appeasement portion. Anything else is likely going to fall under the other $2.975 million in a $3 million verdict, is probably going to be more the deterrence, the justice, the social insurance. The appeasement is trying to make them compensate the victim for what they were beforehand. That's going to include more the pain and suffering, medical expenses, and stuff like that. Maybe some economic loss, lost wages or something like that. Now, the justice portion, the second purpose of tort law, the wrongdoer ought to pay. Now, say you're driving along the road and you get pulled over for speeding. The appeasement is going to be the fine you have to pay for speeding. If you sped and you actually were guilty of doing it, then, if there's a $200 fine, you need to pay that. That's the appeasement. But the justice is the wrongdoer, you, the driver, should have to pay. That is also going to, the $200 is going to be appeasement, but also the justice portion as well. Okay? The tortfeasor, the person committing the tort, should be harmed, i.e. the $200 and, any court-associated time that you have to spend. Now, when we get to number 3, or letter 3, deterrence, prevention. This ticket that you get, the $200 fine, the lights of the police officer, are basically going to act as a deterrent. you're no longer going to speed. Maybe it's for an hour or two, or maybe for a few days, maybe even for because of deferred adjudication, maybe for a period of 90 days or whatever. The people that are driving by the cop with the lights on aren't going to go 90 miles an hour either, are they? They're going to slow down because they don't want to get caught as well. So those lights by the police officer that we see are going to be a deterrent, correct? Well, think of it that way. If we're going to have a $3 million award being given to the old lady for hot coffee, and it spilled on him, even though $25,000 made her whole again, the other $2.975 million is basically a deterrent for other people, correct? If you had a deterrent like that size, you would make safety guards, or you wouldn't do things as much as possible. Do you think like a Sweet Eugene's or a Starbucks even going to lower their temperature of their coffee, or make safer lids that don't come off and spill, or maybe make those little sleeves that go on the cup so that we don't burn our hands if the coffee is too hot? All of those things are going to be done because someone probably got sued and had to pay a lot of damages in determining and using deterrents. That's going to keep, McDonald's and others like Starbucks, Sweet Eugene's, whatever, from doing it as well. So the deterrence portion is there for purposes of tort law. The social insurance is who is the party that's best capable of paying. Now, I talked about in exam 1, if you came for exam 1, what if a McDonald's employee came across from behind the countertop and just beat up a random customer with a baseball bat? Who should have to pay? Obviously, the person that committed the tort, the employee would have to pay, but who is best suited to pay? McDonald's in this situation would be best suited to pay. So the customer would likely sue McDonald's, and under social insurance, because they're the best likely to pay, the manufacturer of the product would be the best, or the employer would probably be best able to pay. They're going to pay. Then they could recover damages maybe from the employee if they so choose. But what's going to happen is, say a $2 million verdict goes because that student behind the counter just goes ballistic on some customer, cusses them out, whatever, and then takes a baseball bat to him. McDonald's has to pay $3 million, maybe $50,000 in damages, and then $2.95 million. The rest of it is going to be based upon punitive damages intended to punish. Well, McDonald's is then going to have a $3 million reward. They're going to basically pay that cost out by spreading out the cost of injury in terms of higher prices later on to make it up. Okay? So we have appeasement, justice, deterrence, and social insurance. Of those, I would note how all 4 of them come into play. And then the one last thing I would notice is if he says something about least cost avoider, that is deterrence, falls under deterrence. But if you're given something about what does the $9 million represent, it's probably going to be appeasement and justice for the most part. If he's just talking about the pain and suffering portion, that's likely going to be just appeasement. If he's talking about McDonald's having to pay and the costs are going to be reflected in higher prices later on, he's probably talking about social insurance once again. Okay, when we were going through those purposes of tort law, we're now on page 113 of your study guide. The damages come into play. One, we have compensatory damages. Compensatory damages are to make the person whole again, i.e. the hot coffee, the pain, suffering, the medical expenses, any kind of lost wages, economic loss. That is going to be determined by the jury, okay, and we're going to come up with it, but those would be compensatory damages. Any other damages as a result of some tort action are probably going to fall under punitive damages. Punitive damages that are not awarded in contract law, so Chapter 4 was not, punitive damages didn't apply, do apply in tort law. So that $3 million verdict for the hot coffee, 2.975 million of it may have been punitive damages intended to punish. Now, some states have tort reform that says it can be no more than 3-4 times the actual damages. If those actual damages were in fact $25,000, then probably if the tort reform says no more than $125,000, that is likely the punitive damages of $100,000. But it's because the reform has said we're going to adopt what we call the English rule, where we're going to modify and limit it to no more than 3-4 times the actual damages. If you get something like $2.975 million in punitive damages, that is not an 8th Amendment violation, and that would be in a state probably that allows for larger damages to be given. All right? Now, when it comes to businesses, how are businesses going to be involved in tort law? Well, an unsuccessful business that doesn't do well, that makes crappy products, shitty products, are probably going to be sued because they make crappy products under, say, products liability or fraud or something like that. A good business, obviously, that does well, people are going to say, oh, they've got money. I'm going to make a frivolous lawsuit against them. We're going to sue them. They're going to just settle out of court and they're going to just give me money. So either way, we're going to go after a good business and try to get some of the money that they've earned, or we're going to go after a bad business because they make crappy products. All right. Now, the last thing on page 113 and the very top of page 114 is very important for especially personal intentional torts, all torts really, but very, for the most part, personal intentional torts. One is we use a reasonable person standard. And when I mean that by a reasonable person standard, not how the plaintiff was acting or thought, not how the defendant thought, but more how would a jury of their peers, how would a reasonable person see a given situation? And when we get to assault and battery, I'm going to talk about that in a little more detail. Okay? So understand this. The jury is going to make a decision, if there is a jury, by a reasonable person, an average person standard. So when you're taking the exam, you have to think like a reasonable person would. How is a reasonable person going to act? Well, if he gives you a storyline and says this is potential assault based on reasonable person standard, or this is a battery, you might have to think like Swim. Swim thinks it's reasonable. Then he is the average person on the exam because he's grading it. You need to note that for the test as well. Okay? All right. Anyway, so let's go on top of page 114 of your study guide. In intentional torts, it is meaning to do the act, not necessarily to harm, but you meant to do the act, and that act resulted in harm to another. I cannot preface and say this enough. You meant to do the act, not necessarily meant to harm anyone. You meant to do the act, but that act resulted in harm to another. Say you're in kindergarten and someone from behind pulls a chair out during the cafeteria. Okay? They meant to do that act. And say a kid falls, spaghetti spills everywhere. Okay, no big deal. It's a big joke. Okay? But what if that kid actually fell? When he fell and hit the ground, broke a bone in his pelvis, okay, or was injured because of that? Could he or his parents sue on behalf? Did you mean to pull the chair out? You didn't mean to result in harm. You were doing it just as a joke. But if you meant to do the act and that act resulted in harm to another, i.e. damages, it could be emotional when we get into later on. But if you meant to do the act and that act resulted in harm to another, then yes, you can be held responsible for a personal intentional tort. Okay. Now, when we get to personal intentional torts, we are going to have 8 personal intentional torts. Assault and battery are 2 big ones that are going to be combined together. These 2 big ones are going to be combined together sometimes and can be quite a few questions on an exam. In fact, I've heard of it being at least 10 to maybe 15% of the actual exam is just basically assault and battery questions. You get a high emphasis at chapter 5. Then assault and battery is going to be one of the big 2, as I say, when it comes to the personal intentional torts. In conjunction a little bit later on, invasion of privacy and defamation of character, those 2 as well can be combined together. Those are going to have quite a few questions as well. So those 4 personal intentional torts are probably the biggest 4, but all 8 of these personal intentional torts we're going to go over have questions. Now, when we're doing personal intentional torts, this is where if you're having difficulty in contract law and you had difficulty on the exam in, say, contract and scenarios, you might have difficulty on torts, especially personal intentional torts, because this is also going to be a lot scenario based. Here's my best rule of thumb to teach you for personal intentional torts when it comes to answering questions, eliminating answers on the exam, and kind of going through each one to make sure it applies to a given situation. The first thing is, if you're a memorization person, you need to memorize the definition of each of the 8 personal intentional torts we're going to go over, including any criteria associated to it. And then know those key phrases and make sure that those key phrases are there. Okay? The first one we have is assault. If I commit an assault, I am the tortfeasor. If you are injured because of my assault, then you are considered to be the person, the plaintiff, committing or suing me. I'm the tortfeasor. I'm likely to defend the person that committed the assault, or in terms of didn't or did not commit, jury their peers. Okay, the first one is assault. If we look at the definition, it is an intentional act placing a person in fear or apprehension of immediate bodily harm or offensive contact. Now, when we go through this, we need to first of all go through reasonable person standard once again. In a reasonable person standard, remember, it's not how the tortfeasor thought of it. It's not how the plaintiff would have thought about it. How would an average person be? Now, as we go through that, let's go over the definition. Well, all these definitions are going to be an intentional act because we're in intentional tort. Intentional means you meant to do the act, not necessarily the harm, but you meant to do the act. The next word that's important in that definition is fear. Assault is all about fear. In criminal cases, when you have a crime of assault, that is completely different. That's more like battery in tort law. The crime of assault is more the tort of battery. The assault, in terms of a tort law, is the fear. Okay? And were you in fear? So if you're in fear of immediate bodily harm or offensive contact. So the question is, are you in fear of immediate, that's our next word, immediate bodily harm or offensive contact? Either way, those can be done. Now, if we're talking about immediate, an example of this is, what if some young kid in school, say a third grader, is in school, elementary school, and some kid, some sixth grader, comes up and shoves him from behind, okay? He didn't see it coming, never saw it coming, gets shoved to the ground. Do we have an assault? Do we have a battery? Do we have both? Do we have neither? The first thing is we're talking about right now is assault. We'll get to the battery portion a little bit later. The assault. There was no fear. There was no fear by the third grader because he never saw it coming. Now, if he had been turned around facing the guy, not from behind, and the guy shoved him from behind or shoved in front of him, then that would be a possible fear, especially if the kid's much bigger than him. Okay? Would the average third grader be in fear of the average sixth grader shoving them in front because they saw it coming? If it's from behind, they never had a fear. Okay? Now, would that be bodily harm? Yes. Or would that be offensive contact? Probably so. So could he sue for assault? More than likely, if he saw it coming, there would be a fear, reasonable fear. Average person would be in fear of the tortfeasor's actions. That would be a definition of possible assault. It would not, however, be assault if he didn't see it coming because I shoved him from behind. If I pull out the chair and you never saw that chair being pulled out from under you, then there's not going to be a fear, so therefore there's no assault. Okay? Now, what if I take, and this is a toy gun, but what if I took a gun and pointed it at you, okay? If it's a real but unloaded gun, or it's a toy gun but it looks real because it's nighttime, would you, an average person, be in fear of that gun? Whether it be loaded or unloaded is irrelevant. The fear is the aspect that we're asking about. A reasonable person, if a gun is pointed at them, unless they know it's fake, would think that that is a real gun and would have a reasonable expectation of fear from the tortfeasor's actions, the person's actions. So that would be a fear, even if the threat cannot be carried out because it's a toy gun or it's unloaded or it has blanks in it, the fear would be there, therefore an assault has occurred. There'd probably be no battery, but there would definitely be an assault. Okay? So the question is whether the fear can be legitimate or not. If the fear can be legitimate, then there is an assault. Now, the next question you have to ask yourself is that person in fear? So say we have a 100-pound girl soaking wet, and she gets mad at her boyfriend who is, say, 6'5", 260, pure muscle, okay? And after getting in a fight, she slaps and goes, asshole, and slaps him. Do you think the average person would think that 6'5", 260-pound pure muscle guy would be in fear of a 100-pound girl who slapped like that? Probably not. Therefore, there would likely be no assault by the 100-pound girl against the guy because a reasonable person would do it. We don't care about what the 100-pound girl thought. We don't care about the 6'5", 260-pound guy thought. What would a reasonable person, what would swim think, so to speak? And my thought process would be there was no fear from the 6'5" guy. Now, what if the tables were turned and the 6'5" guy were to backhand the girl and the girl was to go flying? Well, not only do we have a battery for the actual contact, but would a 6'5" guy looking to backhand a girl, would that average 100-pound girl be in fear? And the answer to me is the average person would say yes. Therefore, there would be an assault in that situation. because we're talking about the fear. Okay? Now let's go back to that storyline about the third grader and the sixth grader. So the third grader gets up, say all he's done has been embarrassed, no actual injury, but he turns around and he tells the sixth grader, when I get bigger, I'm going to beat the crap out of you. Or I'm going to get my older brother next Tuesday to beat the shit out of you. Okay? If he says those things, then is that an assault by the third grader to the sixth grader? And you have to ask yourself, going back to the definition, is that an intentional act? Yeah, the third grader said it and meant to do it. Okay? Did it per se place him in fear? It could obviously place him in fear because, I'm going to kick your ass later, or I'm going to get my older brother to beat you up. That can place a person in fear. But is it an immediate bodily harm? And the answer is no. Maybe next Tuesday it's more immediate, but not right now. Therefore, there's no assault there either. Does that make sense? Because what we're trying to say is not only has to be their fear, but there has to be immediate fear. Whether there's contact or not is irrelevant. For an assault, contact is irrelevant to the situation. For battery, yes. But for assault, no. We're talking about the fear. Okay? So if I point a gun at you, whether I shoot you or not is irrelevant to assault. It's whether or not there is a fear. If it is a real gun, there's probably going to be a fear. If it is a toy gun at night where you can't tell, or there's no bullets in that real gun, there's still going to be an expectation of fear, so you could be sued for assault, regardless of contact, because contact is not necessary for the assault. All right? Now, if you look at the West Hill versus Western Union Telegraph on the bottom, page 114, that you might want to look over. I haven't heard that test being on the exam, that case being on the exam, but we will. You might want to note just the storyline associated to it. He was found guilty of assault in the regular trial, and then it was overturned on appeal. All right. The next one we need to go over is battery, and then we're going to go over assault and battery combined. Battery is the intentional act of physical contact or offensive touching of someone else without his or her permission. Now, we got to go through that definition once again. Touching can be either direct or indirect when it talks about physical contact or offensive touching of someone else. But once again, for battery, let's go through that definition once again. An intentional act of physical contact or offensive touching of someone else without his or her permission. So now let's go through that definition. One, intentional act, that means you meant to do the act that resulted in harm to another. Now, do we require physical contact or physical harm? And the answer is we require physical contact, but it is not a requirement for physical harm. And if you look at B on battery, B on page 115 says physical harm not required, just offensive. And then C says, however, physical contact is required. And here's the way I was talking about being another question on the tortfeasor. If he says the tortfeasor committed a battery as long as physical harm was required. Or Ted, the tortfeasor, committed a battery as long as physical contact occurred. The better answer is the physical contact, because we don't care about physical harm. It's not required. Now, if physical harm occurs, then obviously it's going to be something that falls into battery, but the physical harm is not required, just offensive. Physical contact, however, is required. Okay? Now, this physical contact could be direct or indirect. If I shoot a gun at you, real gun, and shoot a bullet at you, I didn't physically assault or physically batter you with the gun, but I committed it through indirect, the gun. If I throw a rock at you and hit you, or throw a baseball at you and hit you with that baseball or that rock, that would be a direct physical contact. Now, physical contact is required. So if I shoot a gun at you and miss, do we have an assault? Yeah, probably reasonable expectation of fear. Do we have a battery? No, no battery, because there was no physical contact. If I throw a rock at you or throw a baseball at you on purpose to try to intend to injure you, and I miss, we may have a fear, so an assault, but we do not have a battery. Okay? All right. Physical harm not required, just offensive physical contact is required. Now, because of that, assault and battery can occur together or separate. Now, I told y'all, remember I told you girls don't sit on the front row? Well, there's no girls in this online video, so I'm just going to be doing it like this. What if I was to go up to a girl and I was to ask her to dance, and she says no? That's that R-word rejection that we had on exam 1 for contract law. So because of that, I'm a little ticked off and I just go out with my hands like this, and try to grab her breast. Don't touch, but I tend to. Would that be an assault, battery, both, neither? Let's go through. Would that action, doing this, and grabbing at someone's breast, some girl's breast by a guy, be an intentional act? Well, obviously it's intentional. I meant to do that act. Would that place a person in fear of immediate bodily harm or offensive contact? Most average females would consider that to be offensive contact. So therefore, we would have an assault possibly in that situation if I was to do that, correct? But no battery because I didn't touch anything. But what if I actually touched and grabbed and squeezed? Now, if you saw it coming, we have an assault. And if you saw, and I actually make physical contact, then we have a battery. Now, the question is, could I avoid liability on the battery by saying, hey, there was no physical harm to the woman's breast by me, the tortfeasor, therefore there's no battery? Or would the lady that sues me for that battery be able to say, oh, well, physical harm wasn't required, just offensive contact? And the answer is offensive contact. Offensive touching is good enough. Now I've made the physical contact. It was offensive to the average female, so therefore the jury would likely find that that is a battery. Whether there was physical harm to the breast at all would still be offensive, and therefore the physical contact would meet that offensive touching of someone else without his or her permission. Now, if the girl gave me permission, which is very doubtful, knowing my luck, anyway, without his or her permission, the physical contact would likely commit a battery. Now, how would that be an assault but not a battery? If I did this but didn't touch, that's an assault. If I grabbed from behind, reached around and grabbed from behind where you never saw it coming, we might not have an assault because there's no fear, but we definitely have the battery. Okay, so you could have that situation where we're talking about someone being kind of a little pervert and grabbing someone like that would be an assault versus a battery, depending on the situation, or it could be both. If I reach out, you're offended by that, that's an assault because of the fear of immediate bodily harm or offensive contact, and then I actually grab, we have both an assault and battery. Then, would I be able to defend myself if you were to sue me, the tortfeasor, for assault and battery? First of all, did the girl give me permission? If she didn't give me permission, then there's probably gonna be assault and battery. But if I was given permission, i.e. she consented to the action, then I'm fine. Now, in sports, and he has a sports-related question on there. What if you're playing football and you intercept a pass by the quarterback and now you're on defense and somebody tackles you from behind? You never saw it coming because you were running, trying to score a touchdown. So there was no fear of being tackled. But hey, you were tackled to the ground. Could you then sue for battery? No, because you consented by going onto the field of play, correct? Now, if I dunk a basketball after stealing it from you, and I dunk a basketball, and then as I leave and turn around, you deck me, you just punch me, then that goes beyond the level of consent of a sport. If I was to foul you as you're going up for a shot, then that would not be an assault or battery, would not be a battery because it's applied level of consent. But if you were, after I dunk on you, were to turn around and hit me, then that would likely consider to be a battery because that's not a part of the implied consent of playing in a sport, okay? Now, also defenses to assault and battery, if a police officer pulls a gun on a suspect, then that would likely fall under there as long as they don't commit or go overboard because then it's going to be police brutality, but they do have privilege for certain assault and battery claims as long as they don't go past the beyond level. Now, the last one that we need to go over is self-defense. In Texas and most other states, we are allowed to reasonably defend ourselves from force, or defend ourselves or others or our property using reasonable amount of force. Now, what is reasonable? Reasonable, once again, is the average person standard. Would the average person in this situation consider that to be a reasonable amount of force? Can you use deadly force? Absolutely, you can use deadly force if it's first used against you. Okay, first used against you. In most states, deadly force cannot be used in terms of your property protection, only to protect yourself or others, and only if deadly force is first used against you. Now, what is deadly force being first used against you? If an armed robber is going through your house with a gun or say a machete or something like that, a knife or something like that, then yeah, if they're searching around the house, then deadly force is being used against you, you can protect yourself, not only with reasonable force, but maybe deadly force as well. There is no duty to flee in Texas. In many other states, a majority of states, there is a duty to flee. So if someone is coming into your house with a gun, if you can get out that second-story window and leave, or leave by the back door or something like that, before you commit deadly force against them, you must attempt, at least try to do so. Now, if you can't do it, if you cannot flee, if you have no ability to flee, then you may use deadly force to protect yourself. But in many states, you have a duty to flee. Texas, at least criminally, does not require a duty to flee. So you can stand your ground. Texas castle law, the Colorado Make My Day law, the New York stand your ground law give more protection for use of deadly force against someone if deadly force is used against you. But what should you do? You should attempt to flee the situation. Okay? You should attempt to flee the situation, but if deadly force is being used against you, then you may use deadly force to protect yourself, others, and in some weird cases, in some weird situations, your property as well in Texas. So what we need to know about Texas is there is no duty to flee, no duty to flee. However, okay, you must attempt or try to flee would be the best thing to do. What should you do versus what must you do? You're not required to flee, but you should flee. And there is a difference between maybe answer B or C on the exam in what would be the best scenario to do. Rather than killing someone, you should probably try to flee the situation if you can. All right. That is battery. If you look on the very top of page 116, we have, in reality, Texas is a very conservative state. We have far-reaching gun laws. Texas jury is much more sympathetic to the gun user. Okay, I think I'm going to end the first video right here. We still got about 3 or 4 more videos for the red packet, but I'm going to go ahead and end the video now and start up a new video. We'll see how this one goes. I'm probably going to take a look at this one and make any little changes as well.